Right, well, good morning, everyone. My name is Alistair Edwards. I am a reporter with the Scottish Government's Planning and Environmental Appeals Division, otherwise known as the DPA. Can everybody hear me first off? Brilliant. Okay. We're here today to discuss the procedural arrangements for an inquiry to consider an application under Section 36 of the Electricity Act 1989 by North Lowther Energy Initiative Limited for a wind farm comprising 30 149-metre-high wind turbines and associated tracks, buildings and infrastructure on land located on the Queensberry estate. I've been appointed by the Scottish Ministers to hold the inquiry and thereafter report to them with a recommendation on what should happen to the proposed development. Now, there are a few housekeeping matters before we proceed. Firstly, please note that today's meeting is being recorded for subsequent broadcast via the DPA's website by my colleague Ewan at the back of the hall. Generally, the public seating areas will not be filmed. However, by entering the venue and using the public seating area, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Any information presented by you to myself, in addition to forming part of the webcast that will be held as a historical record, will also be held and used by the DPA in connection with the relevant matter until that matter is decided or otherwise resolved. Thereafter, that information will continue to be held as part of a historical record. Now, are there any questions about filming before I proceed? No. Now, in terms of using the microphones, it's very simple. You push the button in front of you, it will go red, that means you're live, and the camera will pan to you. Once you turn it off, someone else can take part. If two of you use the microphone at the same time, I have an override function because the audibility won't work correctly. Is that clear? Brilliant. Now, toilets are located just out the hall on the left. Ladies are at the far end of the corridor, gents are double left. There's no fire drill today, so if the fire alarm goes, it's for real. If you can exit either by this door here, turn left and make your way to the car park at the front, or out the main entrance that you came in. I'd ask that you keep any mobile phones switched off or silent during today's discussions. If you're in the audience, there is a clipboard at the front. If you wouldn't mind filling that in with your details, that would be much appreciated so we have a record of who attended. It also means that we can send out the minutes of this meeting to you after if you so wish. It should also be noted by opting in, you've agreed for your data and email address to be shared between parties. If you're unhappy with the particular email address or contact details that you've given me to be shared, please get in touch with me at the end of the meeting and we'll make sure we have an email address that we can use that can be shared. Does everybody have a copy of the agenda for today's meeting? Okay. Now, I'll ask each of the principal parties to introduce themselves, starting with the applicant.
Yes, sir. Good morning. My name is Gordon Steele, and I'm representing North Lowther Energy Initiative. I'm instructed by Shepherd and Wedderburn, and in particular Mr. Innes, who's on my left, to whom all correspondence should be addressed.
Sorry, just for my purposes, would you mind just going down the line and telling me who's sitting at the table?
Yes, sir. Well, Mr. Innes is on my immediate left, who I've already identified. Then Mr. Ian Sim, then Mr. Alistair MacLeod, Mr. David Bell, who's the planning consultant, and Mr. Mark van Grieken, who is or will be one of the landscape and visual consultants. I think that's everybody at the table, sir.
Okay, and Dumfries Galloway Council?
So may it please you, I appear on behalf of both Dumfries and Galloway Council and SNH. My name is James Findlay. On behalf of Dumfries and Galloway Council, I'm instructed by Laura Whitelaw, who sits to my left, and the remainder of the Dumfries and Galloway team are behind me there: Janet Swales, Robert Duncan and Andrew Robinson. To my right sits Paul Taylor from SNH, and to his right Lindsay declines from SNH.
Okay then, and then on behalf of Oliver Mundell.
I'm Erin Stevenson. I'm here representing Oliver Mundell, the member of the Scottish Parliament for Dumfriesshire.
And Wanlockhead Community Village Council.
Hi, I'm Isabel Gibb on behalf of Wanlockhead Village Council.
Hello, I'm Andrula Richford and I'm from the Wanlockhead Village Council.
Hello, I'm Gerard Godfrey representing Lead Hills Community Council.
Thank you, Mr. Godfrey. I just have one point of clarification from yourself. You've written as an individual and on behalf of Lead Hills Community Council. I just want to understand, are you proposing to participate as both the Community Council and as an individual?
I was just wanting to make a personal statement at the end, really. It's slightly different to in the slant would be different to that for Lead Hills Community Council.
Thank you. Now, Scotways has indicated that it wishes to participate, but it cannot attend the proceedings today. As we will get to shortly, I've indicated where I think Scotways may be involved in the proceedings. Similarly, David Mundell MP, the Lowther Hill Ski Club and Mary Steen have opted into proceedings, but they haven't responded in relation to attending today's meeting. However, they will be given the opportunity to take part in the process as we agree today after the minute goes out. Is there any other organisation or person that would like to take part in proceedings? No? Okay. Moving on to item 2. There are no statutory rules to Electricity Act cases. Therefore, I intend to deal with the inquiry in accordance with the Code of Practice for Electricity Act cases, which is available from the DPA website and was circulated in advance of this meeting. Using the code allows for flexible procedures. Each issue can be dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, sufficient information will already have been submitted and no further procedures will be required. When I write my report to Scottish ministers, I will take into account all the environmental information submitted by the applicant, together with all the consultation responses, letters of representation and petitions already lodged, and evidence arising from the inquiry process. The type of procedure being followed or the absence of any further procedure does not affect the importance of a particular issue. Before we go on to look at the list of issues and my provisional assessment of how these issues could be addressed, as circulated on the agenda, I want to explain briefly the differences between the procedures for those of you who haven't been involved in anything like this before. Further written submissions involve a series of written questions from me specific parties are asked to respond to. Parties can then comment on one another's responses to these questions. In practice, it allows a full exchange by all parties on an issue without the need to discuss matters. Hearing sessions take the form of a structured discussion between parties involved, which I would lead. There's no formal leading of evidence or cross-examination. I would prepare an agenda for each of the hearing sessions in advance. Everyone who has advised me that they wish to take part can participate in a particular hearing session. There's no need for legal representation, although parties' lawyers can take part in the discussion. Hearings are generally more informal than inquiry sessions and are particularly suited to topics where there's a difference of opinion on less technical issues. For an inquiry session, each party would be invited to present evidence in turn, and this would be subject to cross-examination by those of an opposing view. Usually parties are legally represented and lawyers will question or cross-examine the witness. Although it is not essential to have a lawyer present, I will also have questions. Inquiry sessions are more formal than hearing sessions and are particularly suited to topics where there's a lot of technical evidence, such as where there's contradictory expert advice. Now, are there any questions from party concerning the various processes available?
Yes, sir. Indeed, I've got a submission to make to you, which relates to your paragraph 2, 3 and 4. and it relates, sir, to the clear and unambiguous terms of the Electricity Act. And this is a submission that I have made before at similar inquiries or similar pre-inquiry meetings. I have got a copy of the Electricity Act to the relevant pages if it would be helpful to you, and I don't know whether you wish me to make a detailed submission about this now or whether I can take the matter very briefly. I think it's reasonably well understood.
Yes, I think if you want to continue now with a
Right,
short
sir.
submission.
The position is that obviously this is an application for consent in terms of Section 36 of the Act, and therefore is governed by the terms of the Electricity Act 1989. If one turns to Schedule 8 of the Act, the terms are relatively unambiguous. If one looks at Schedule 8, Section 2, under the heading Objections by the relevant planning authority, and there has, of course, been an objection, which I have in front of me, by the relevant planning authority. And the terms of Section 2.1 are as follows. Where an application is made to the Secretary of State for his consent under Section 36 or 37 of this Act, notice of the application shall be served on the relevant planning authority, which clearly has been done. I now get to the critical bit, sir. Where the relevant planning authority notify the Secretary of State that they object to the application and their objection is not withdrawn, the Secretary of State, and I quote, shall, being a mandatory requirement, cause a public inquiry to be held. And for guidance as to what that might mean, if one turns the page to the objections, the heading Objections by Other Persons, Section 3.2, there is drawn at that point a clear distinction between a public inquiry or a hearing or any other method of stating an objection, which obviously would include written submissions. Therefore, and I can read that to you, sir, precisely if required. Therefore, it is clear that the requirement is to have a public inquiry, not written submissions, and not any other hearing. In addition, sir, there are precise rules about advertisement in relation to the public inquiry to enable the public to participate in the public inquiry. So the short point is, sir, there requires to be an inquiry rather than hearing or hearings or written submissions. And apart from the fact, sir, that we would prefer an inquiry, particularly in relation to certain aspects, the real anxiety is that if a party is denied a public inquiry when they have asked for one and they are entitled to one, there could readily be a legal challenge to this procedure and any decision that may or may not arise as a result of this procedure, sir. And I pause to note that Lead Hills Community Council, in their very well-framed objection, which must have taken some considerable time, set out at more than one page, under the need for a public inquiry, their desire to have a public inquiry, both for Harryburn, which doesn't concern us today, and for this proposal, and they set out cogent reasons for wishing that to happen. So the concern is not a fanciful one, because one could readily imagine that members of the community, possibly Lead Hill Community Council, if they feel they have been deprived of their entitlement to a public inquiry, could take legal action, which would be regrettable for all parties. So, sir, in my submission, there is a legal obligation to have an inquiry.
before I come to the other side of the table here, so your submission, sorry, Mr. Steele, is everything that I've outlined today should be subject to an inquiry?
Sir, firstly, I should have added that I made an identical, or virtually identical submission at a particular pre-hearing to do with wind farm sites at Creggans before Mr. Ferry. And we quickly reached a situation where we had a public inquiry which dealt with all matters. At the end of the day, sir, it will be a matter for you to precisely how you handle this, but the legal position is tolerably clear. If there are very minor matters, they can easily be covered, for instance, in a line or two by Mr. Bell in a precognition, and that would be within the ambit of the public inquiry. You said all matters, conditions clearly might be within the inquiry session, but slightly more flexible, if you follow me.
Right. Before I put this across to the other side, obviously the default is to have an inquiry. That's the default situation as I understand it. However, the code of practice has been endorsed for many years now, possibly up to a decade, and is regular practice to use that code to have what I would call expedient processes, so ones which are useful, because we have to think at the end of the day, what is this process about? Yes, it's about looking at the evidence, but it's also about providing a coherent report for the ministers to make a determination on, and therefore it's for myself to gather the most appropriate information, and obviously for parties to provide the information that they think is vital to their case. We have Gerard Goffrey here from Lead Hills Community Council. When I asked if the code of practice was being endorsed, he didn't say, actually, I don't agree with that. I think everything should be dealt with by an inquiry, and I'll ask you to confirm that in a second, that you are happy to sign up to the code of practice. Possibly you could also tell me about this risk of a potential legal challenge down the line that Mr. Steele has discussed. So I'll go to you, Mr. Godfrey, and then I'll ask the rest of the table what their thoughts are.
Yeah, when we were asking for a public inquiry, I think we took it in its broadest context, because we were sort of responding really or asking as laypersons, and I mean, we've had a very similar situation up the road at the Harryburn public inquiry that happened just a few weeks ago, and we concluded there that it was perhaps helpful, particularly to the communities, because we're a bit uncomfortable with the actual inquiry session, insofar as, you know, we're not lawyers, we don't have expert witnesses from the community side, and we felt that the hearing session was an appropriate way of the community getting their views across to the inquiry, or to yourself as the reporter, and so we took the term inquiry to mean in its broader sense.
Just to confirm, so you're endorsing, you're happy for the code of practice to be used in this case?
Yes, indeed.
Mr. Finlay, any comments?
So, there doesn't seem to be any dispute between you and my own friend Mr. Steele that the default position is inquiry, but just looking at some of the items on your list, for instance, ecology questions regarding mountain hare, would seem entirely sensible for that to be dealt with in writing. Likewise, issues, if necessary, about access, traffic and transport, just by way of an example. We're happy with the code of practice, but effectively take and would indeed prefer that some sessions be dealt with by full inquiry session and some by hearing session and some by written submissions. The particular matter that just been discussed by Mr. Godfrey was that the Harryburn inquiry, there was a evening hearing session for local residents, which I think is what he's alluding to, at which there was no, there were, I think maybe factual questions could have been asked, but there was a landscape and visual from local residents was dealt with at a hearing session, whereas the professional witnesses were dealt with at a public inquiry session. I hope that's sufficient for your purposes.
Okay, Mr. Steele, we now have, as I mentioned at the start, this pre-examination meeting. Not only will I make a record of it, which will be in the public domain, but it's also being filmed, which is an historical record in the public domain. And you've heard from Mr. Godfrey there saying that he's taken inquiry to mean a wider set of processes. He's not looking for a public inquiry on all the issues that have been raised.
Well, sir, I hear that absolutely. But first, if I may, with respect, suggest that the inquiry is not the default position. The inquiry is actually the mandatory requirement of the Electricity Act. That is the legal position. Mr. Godfrey, I've heard exactly what he has said, but I do wonder whether he's in a position to absolutely bind the whole of the Lead Hills Community Council and any other member of the community. And I say that especially because I do wonder whether Mr. Godfrey has taken appropriate legal advice about this, but is he really able to bind and assure us that neither, no member of the Lead Hills community, or indeed anybody else that is not favourably disposed to us, might not take a legal challenge in the event that consent is granted, sir? I personally would suggest that it is impossible that that is the case, and the risk, I hear what Mr. Godfrey has said, and I note what he said, but I do suggest respectfully that it's impossible for him to have to bind here and now all members of the public who may be disquieted by this application.
Any further comment, Mr. Godfrey?
Well, I can't comment that somebody may come out of the, say out of the woodwork, but somebody may come forward and object to the sort of legal position, as stated by the other side. All I can say is I am sort of mandated by the Community Council to represent them, and that's as far as it goes. Any determination on the legal position presumably will have to be made by yourself, or perhaps in consultation with colleagues at your office.
Right. Mr. Steele, any further comment before I decide how to proceed?
No, sir. I think I've made the position clear, at least I hope I have. Certainly, we would, notwithstanding the clear terms of the Electricity Act, we would most certainly wish an inquiry in relation to the policy context. I don't think I can assist you further. I think I've set out the legal position, I hope, relatively clearly.
Right, well, what I'll do, I've heard what you both had to say on the matter. You've all agreed to using the Code of Practice.
Sir, with respect, I do not agree to using the Code of Practice insofar as it conflicts with the Electricity Act. We do not accept that.
So to be clear, Mr. Steele, as we proceed through the agenda, and we're going to talk about my provisional arrangements for each topic, the default of the applicant will be that each of those should be dealt with by an inquiry session.
Well, sir, again, with respect, it it is not the default position. That is what is clear from an examination of the terms of the Electricity Act.
I'm sorry to press you here, but for my purposes, I need to understand, I completely understand what you're saying about the Electricity Act. But in order for us to proceed using expedient processes, ones that will get us to the end of an examination process without an inquiry for every issue, as we go through, I understand that policy and landscape and visual impact, which will come to, you would like an inquiry. But for those other issues, are you saying that you want an inquiry process, or, as Mr. Finlay said, for something like Mountain Hare, which we'll come on to, could that be dealt with reasonably through written submissions?
Well, sir, to use the Mountain Hare, my proposal would be that there might require to be one line in Mr. Bell, who's the planning witnesses and precognition, to cover at that point, which actually might be more expeditious altogether than having written submissions on that. It is a very minor point and could very readily be covered, and therefore technically it would be within the inquiry process, but it would be even quicker than having some written submission procedure.
Okay, but in that situation, potentially there could be cross-examination based on what you're saying could be a simple situation.
Well, sir, technically, theoretically, that is possible.
Right. See, yeah, Mr. Godfrey.
I think there's an issue here in terms of resources, in that obviously the communities don't have the same access to resources as the applicant, and I just feel that to go through the full inquiry session process would be likely to put the community representation at a disadvantage. But presumably the other side will argue that by not having the inquiry session, it puts them at a disadvantage.
And Mr. Finlay, you're representing the council and SNH. That would pull you into more inquiry sessions potentially.
It does seem to give rise to unnecessarily cost and expense and delay. Because some of the written sessions, there are other parties involved who aren't present in the room at the moment, or may not be, and could deal without having to attend at the inquiry. I can quite understand for particular sessions if Mr. Steele's clients wish a policy session to be held in a full inquiry format, then so be it. But it does seem to us that it's not necessary to have a full inquiry session on every topic. I don't know whether Mr. Steele is suggesting there should be other topics other than the ones you've suggested that need to be examined as well, because that's another issue that may arise. But I'll no doubt hear that in due course.
Right, I've heard everyone's submissions on this. My preference would be that we continue through the agenda, look at my provisional arrangements as set out in the agenda. Obviously, I've heard what the applicant has to say, and I understand what your position is. My preference at the minute would be to try and use procedures which are the most efficient ones going forward. And as Mr. Finlay's just said, there are parties who wish to participate that aren't here today, to which an inquiry session may be problematic. When I do the minute of this meeting, it will also become a procedure notice, which will set out how we're going to do the procedures. Within that, I will state my preference for how we're going forward in terms of having an inquiry or other processes, and we'll take it from there. So, are we okay for us to move on to items 3 and 4?
So you have my submission, and that covers items 3 and 4 as well, I think.
Right, yes, I'm taking your position as an inquiry for these, but we'll work through in any sense, just to understand what the options would be and understand what your position is. Right, parties okay to move on to items 3 and 4? Now, my provisional assessment of the main issues to be addressed in the report to Scottish Ministers and those requiring further procedure is summarised in Appendix 1 of the agenda. Now, firstly, can I ask parties for their views on the list? Is there anything missing, firstly? Mr. Steele.
We haven't spotted anything that's missing from that at the moment, sir, no.
Mr. Finlay?
No, sir.
Okay. And everyone else on that side of the table, you're happy with the content of that appendix? Yes.
Can I just say that I've noted there's nothing on contamination, contaminated ground? Okay.
Now, secondly, I'd like parties' views on my provisional assessment of the procedures for each issue, and we'll take each one in turn. So, firstly, in terms of the policy context, I've opted here for a session on an exchange of written submissions, but I understand that, Mr. Steele, you would like an inquiry on that.
Definitely, sir, yes. Yes. For both the legal reason and practical reasons as well.
Okay, Mr. Finlay, in terms of an inquiry session?
Well, our preference would be for written submissions, but we hear what Mr. Steele says. I do also note your subdivision of the policy context suggests there's scope for agreed statements, and no doubt there will be. And so far as I understand Mr. Steele's position on behalf of the applicants, he is content with the ambit of the session, which should be an update on policy context, including those matters that you've indicated. But I think it would be sensible to have that clarified as well at this stage.
Now, Lead Hills Community Council and Wanlock Village Council, I've indicated that you may wish to take part in that, as you've indicated policy within your objection letters. Is that something that you would like to be involved in?
Yeah, we're comfortable with that. We're quite happy to do so.
So, Mr. Steele, in terms of the actual content of that policy session, be it an inquiry session or written submissions, I've asked for an update in terms of the context. As we know, the LDP examination has completed, and therefore a new LDP will be adopted within the next few months. And also an agreed statement. Is there anything else that you'd like to add to that?
So just to clarify, because of what's said by my learner friend Mr. Finlay, the use of the word update, I assume that doesn't simply mean it's an updated position, because clearly we might want to refer to, or will want to refer to, various policies, not just the most updated ones, and energy policy is included in that, which obviously is important, and we would also want a statement or an examination of the SNH policy position. And I'll be coming to a witness about that later on. So far as the agreed statement is concerned, I would very much hope that there could be an agreed statement encompassing much of the policy background, which would save time at any inquiry, if there be an inquiry, of course, subject to your decision. But broadly, we're happy, but we would want a particular reference to SNH policy.
Okay, Mr. Finlay.
Well, sir, I'm not quite sure what S&H policy Mr. Steele's referring to. Perhaps S&H, for instance, did not give policy evidence at the Harriban inquiry. They have an objection on a case-by-case basis. So it would be of assistance if Mr. Steele would indicate, so S&H can decide whether they wish to take part in the session as to what evidence he might be leading on S&H policy.
I'm very happy to do that now, sir. I was going to deal with that later. But we're fully aware that S&H did not give evidence at the Harryburn inquiry, and we personally thought that was a deficiency. We would like a witness from S&H to explain their position and their policy position in relation to this application now, inquiry or appeal. And we will be asking you at the appropriate time, sir, to encourage S&H to provide a witness or possibly use your powers to require them to provide a witness to explain what their position is in this particular issue.
It doesn't sound as though Mr. Steele's intending to lead any evidence on it. It's a matter for S&H, obviously subject to your direction, whether they need to call a witness, and you can decide whether it's a matter whether you need the assistance of a witness from S&H on policy as opposed to a witness from S&H detailing the substance of their objection. At present, S&H has not formed a concluded view, but its position at other inquiries, many other inquiries, has been that there's been no need for a policy witness, and when a policy witness has a bid at one or two, they've been in effect unnecessary. So the starting point would be that S&H would be calling a witness on the matters of substance, not policy, but we will reserve our position on that.
Yes, Mr. Steele, before I can decide how this could be dealt with, I really need to understand more about the policy. And I don't want to get into evidence here, but it's the policy that we're talking about here. Is it the guidance from S&H that we're talking about? Is it, obviously you have S&H's correspondence. Is it something within that that needs clarification?
I think it's something a bit beyond that, sir. We would like to understand what is the policy of S&H in relation to this wind farm and wind farms in this geographical area. My understanding is that part of S&H's concern relates to the geographical spread of wind farms, and that they have a policy in that regard, and we would like to explore that, both in our evidence, and we will lead evidence about it, and by cross-examination of the relevant witness from S&H. That cannot, of course, productively be done to a witness who's a consultant to S&H on landscape grounds, because he or she wouldn't have the necessary knowledge to be able to answer questions about that. And I should say, sir, that if S&H do not produce a witness about this, then there will be adverse comment about it in our evidence, and no doubt in my closing submission in due course. So we would urge them to, they are a government agency, they have got certain responsibilities, and it's difficult to understand why they wouldn't come along and explain openly and candidly what their position is.
Mr. Finlay.
S&H will always be open and candid, but as far as I'm aware, I don't think we have a policy on geographical spread. We have a reaction to particular proposals, and they're indicated in this case, but obviously I'll take instructions on that. If that's Mr. Steele has highlighted that as the issue upon which he wishes to concentrate, policy on geographical spread of wind farms and wind farms in this area, I'll say no more at this stage, but at the moment I'm certainly not guaranteeing to Mr. Steele or anyone else that we will be producing a witness at the policy session on behalf of S&H.
So can I just draw attention to S&H, their letter of the 6th of October 2017, where S&H identified that the wind farm is located within an area defined as the Lowther Hills on the S&H map of Scotland's landscape and give us a link to it, and then tell us about this being a dramatic range, etc., etc. It is that issue, sir, the policy in relation to this geographical area that we wish to explore and have explained to us. It's clearly within their letter. Actually, I should say, it's not clearly within their letter. It's in the letter, but it's far from clear.
Okay, now I understand, and this is something that I thought might come out in the landscape and visual impact session in terms of this SNH map of Scotland's landscape and the matter of national interest in terms of a policy position. Mr. Finlay, is that something that needs to be your SNH landscape witness could respond to?
So I think you'll be, having had the advantage of appearing at another inquiry before you where the landscape map of Scotland was considered, you'll be aware of what it is without needing to go into the evidence. It's simply a map of the whole of Scotland with a description of various areas within that. What then goes from there is another matter. In our submission, it's not a matter of policy, and it's a matter that is quite capable of being dealt with by a landscape and visual witness. But as I say, if Mr. Steele is wishing to examine, have a witness from SNH here to explain the process of objection, and I think they have all the SNH documents having undertaken a Freedom of Information Act request. That's another matter. That's not a policy matter, and that is entirely a matter for SNH as to how it wishes to present its case.
Okay, any further comment, Mr. Steele?
Simply, sir, to draw attention to our position statement from November 18, where we raised this very issue at paragraphs 121, 122 and 123. And at 122, having set out the SNH objection, we say the site and surroundings are not subject to national designation, and SNH provides no evidence to substantiate that the site makes an important contribution to national distinctiveness, and there's therefore no policy basis to object on this basis. That, sir, is the nub of the issue and our concern about this. We want to truly understand whether there is soundness in the SNH position or not, and it would be impossible for that to be spoken to by a consultant who simply comes along to deal with this site on a one-off basis. There's something, it appears, underlying all of this, and we want to establish what that is, and only SNH, the relevant official from SNH, can tell us. And it's disappointing that SNH should be reluctant to proffer a witness, but I leave it with you, sir.
Right. Is there any other content that would require to be discussed under a policy session or written submissions? No. In that case, we'll move on. What we'll do, we'll go through each of the processes, and at the end we'll determine who's going to be involved in each of them. So in terms of landscape and visual impact, I've indicated a potential requirement for confirmation from MOD in terms of lighting, and also to have a full inquiry session. Is that agreed?
Obviously, we're in agreement with the inquiry session. In relation to the MOD, sir, we expect developments on that front very soon. We're in advanced discussions in relation to these matters, sir, and we'll be able to update you at or before the inquiry session on it.
Okay, so as opposed to myself requesting a further request from the MOD, you're saying the applicant will be forthcoming with that information?
I believe so, sir. Well, we don't physically have it at the moment, but I understand and believe that to be the case.
I'm just thinking for my purposes, obviously the procedure notice from today will set out a timescale, and if the MOD information comes in before, that would be useful, but it might be useful to put that in the procedure notice just to ensure that it does happen one way or the other.
Sir, on a precautionary approach, if you put it in the procedure notice, events may overtake it in any event.
Mr. Finlay, any comment in terms of an inquiry for LBIA?
No. Other than we agree.
Sorry, is that for both your representees?
Yes.
Now, in terms of the Wanlockhead Village Council and Lead Hills Community Council, would you wish to participate in a landscape and visual impact inquiry session?
Certainly we didn't at the Harryburn. That was sort of the community view of landscape and visual impact was dealt with as part of the hearing session, sort of separately. I suppose it was handled on a sort of dual way by the reporters in that there was an inquiry session, but also the community view was dealt with by a hearing session. And if it came to the crunch, I mean, I'm sure we would accept the situation if it was held, if there was only an inquiry session.
And Wanlockhead Village Council, any?
I think we would like to attend.
Sorry, I was just checking both of your objection letters to see what you'd said in terms of landscape and visual impact assessment, and you certainly do make some comments that would align with an inquiry session. You wouldn't require legal representation. We'd be able to aid you through that process if you were to participate. And you understand that participating, you would be subject to cross-examination, but you would also be allowed to ask questions of the other parties' witnesses.
Yeah, I think we obviously feel a bit uncomfortable about the cross-examination side, but it gives us the opportunity to cross-examine the other side, and I think we're happy to accept that position. Yeah, thank you.
Thank you. Okay, as we go through, obviously we're agreeing processes, and I've had time to contemplate your submission earlier, Mr. Steele. So my preference would be using the Code of Conduct, and that's not dismissing your submission, and that will be made. I will make that clear within the procedure notice a minute of this meeting what your submission is. My preference would be that there is a written exchange in terms of policy matters. I don't feel at this point in time that having a witness from SNH would be useful. However, I do feel that a witness in terms of the landscape and visual impact inquiry session, which I'm proposing should occur, would be able to pick up on the matters that you've raised. If we find at the end of that inquiry session that it's been the outcome is unsatisfactory, there is always the potential for a further process. So for policy, I'm looking at written submissions, and for landscape and visual impact, an inquiry session. Moving on to socioeconomics, tourism, recreation and community impacts, I've indicated a hearing session, and what I'm proposing here is to have a hearing session which is fairly all-encompassing. One which talks about job creation and potential employment impact, predicted investment, the impact in terms of tourism, recreational assets. Under community benefit and shared ownership, I also wanted to look at the issue of community buyout through the Community Empowerment Act, which has been raised by several parties, and also to discuss flood risk and contamination issues. Now, Mr. Steele, I realise what your position is, but my preference, particularly because it's associated with more community impacts, would be to have a hearing session where we could discuss these issues. Any comment?
Sir, I've already made the position absolutely clear. I would also add to it that under this topic is indeed contamination, which was raised as a concern by a local resident. Flood risk and contamination, these are particular specialist topics, and they, in my submission, most certainly would require an inquiry session, regardless of the clear provisions of the Electricity Act, sir. So in relation to this issue, the position is, I suggest, both clear in relation to the Electricity Act, and from a practical point of view, it would also merit that. These are important matters raised by a number of parties, but I cannot say any more, sir, if you have decided, so to speak.
I haven't fully decided yet. This is my provisional for this particular session. Mr. Finlay, any comment?
So, only now commenting on behalf of the Council, we would have been happy with written submissions given our views, but we're quite content with a hearing session if that's what you determine.
Now, I've obviously indicated quite a few parties that may wish to take part in this if it is a hearing session. Ms. Stevenson, in terms of Oliver Mundell, any comment in terms of his participation in that?
If scheduling allows, he'd be happy with a hearing session.
Wanlockhead Village Council?
On behalf of Wanlockhead Village Council, we'd be happy to attend a hearing session.
Lead Hills Community Council?
Yeah, we'd be happy to attend a hearing session. I would point out that at the Harryburn inquiry, we dealt with these issues as part of the hearing session, and indeed the other side actually provided somebody who was an expert on sort of flooding and mine contamination, and so it did work. It worked fine as a hearing session.
Now, obviously, in preparing for today, I've read the majority of submissions made, and the applicant has made responses on many of these issues. So, in many respects, a lot of these issues have already been contained. I feel that a hearing session would be the most useful means of going forward in terms of having a discussion, and that's not to dismiss what Mr. Steele has said in terms of the specialisms of flood risk and contamination. However, in my experience of this in the past, despite the fact that they may be specialist, I feel that a hearing session would be useful, and it's particularly interesting to hear that that worked in the Harryburn wind farm situation. So going forward, I would propose to hold a hearing session on that. Any comment before I move on?
So you already have the submission on the matter. I'm not going to repeat it.
Okay, in terms of hydrology, hydrogeology, geology and soils, the applicant has produced a response which talks about an updated peat stability assessment. Is that the case? And if it is so, then I'm proposing further written submissions to involve parties that have an interest in peat, particularly SNH and SEPA may be involved as well. Any comment from Mr. Steele?
If you just give me a moment or two, sir. we believe, sir, that SNH's concerns have been addressed in relation to the issues listed here. But obviously, my learned friend Mr Finlay will be able to confirm that.
I wish I could fulfil Mr Steele's confidence. That may well be the case, but the part of SNH that's dealing with this subject is not sitting beside me at the moment. So if Mr Steele indicates that, as far as he understands, SNH is satisfied, I'm certainly not going to doubt that. I would obviously need to formally confirm that. No doubt that that's information he's been given by the appropriate person in his team.
Well, indeed, and I have in my hand an email from Mr Corbett, dated the 20th of August, which seems to state exactly that.
My difficulty is, just to confirm firstly, that there has been new updated P information. There has. So in that case, we're now in a situation through the EIA regulations, Electricity Works regulations, that's supplementary information. So in effect, ministers have to request that information for it to become part of the inquiry submission. So despite the fact that SNH seem to have correspondence, I don't have that. So I would propose a quick further information request, written exchange, to confirm that.
Yeah, I'm surprised that you don't have that, sir. There was an FEI in relation to this issue, and this occurred at the middle of last year. It's not something new, but if you don't have it... Yes. Right, and my understanding is that that addressed the concerns of SNH.
Okay, so it was new P information. It's been submitted. SNH have come back saying that they're okay with that as of August 2018.
I believe that to be the position, sir. Obviously, my learned friend, Mr Finlay, will require to get up to speed on that, but I believe that I have an email here to that effect from SNH, dated August 18.
So in terms of my timeline, the reason that I've raised this is obviously I have the environmental statement, you had further environmental information, and I was understanding that this was new information that came beyond the FEI. Is that correct?
Sir, I do not believe there's new information beyond the FEI of August, or culminating in August of last year. There is, or may have been, clarification of that, but I'm not sure that it constitutes new information. But if you wanted to operate on a precautionary basis, you could request such information. Of course, you could have an inquiry which would unearth all of this so much more easily.
Okay, I'll have a think about that. I'll read over the submissions again and decide whether or not clarification is required as a precautionary approach. Moving on to ecology, I've written down here a question regarding mountain hare. This particular species was raised by, I think, Mr. Godfrey in his submission. I've noted from the ES that there's mention of brown hare, but I couldn't see a mention of mountain hare. Is that something that I could usefully have a quick exchange and written submissions on?
You can certainly have an exchange, sir. Whether it proves to be useful or not, as I understand it, this amounts to a photograph of a mountain hare. But beyond that, I'm unclear as to what the position is, quite frankly. But no doubt matters can be made clear by one means or another.
Mr. Godfrey, any comment?
Yeah, I think this is an issue that can be quickly dealt with by exchange of letters. So I'm sure we can come to an arrangement there.
Okay, we'll deal with that through further written submissions very quickly. In terms of ornithology, cultural heritage and noise, I'm saying no further procedure. Is that agreed by all parties?
Well, sir, you have the earlier submission. These relate to concerns expressed by local residents, as I understand it. Ornithology is touched upon in the committee report by Dumfries and Galloway officials. I can say no more than that at this stage, other than what I've already said, obviously.
No need for any further process on any of these.
Is that agreed down the line as well?
Yeah, I think we, certainly at the Lead Hill side, we had some concerns relating to the ornithology, in that we felt that RSPB and SNH tend to take a mechanistic view as to as to the designation of various areas as protected areas for birds, rather than where the birds actually are. And there are a lot of protected species which are in the Lowther Hills on the applicant's site. And but we recognise that at the end of the day, we're not experts on birds, and I think we have to go with the position of RSPB and SNH on that.
Okay. So, sorry, Mr. Steele, just to confirm, are you asking for an inquiry on these three matters, or you're happy with no further process?
Sir, I've made the earlier submission, which I will not repeat. Sir, in relation to cultural heritage, I wonder what distinction there is and how we will draw distinction between cultural heritage and the issues that you have raised under socio-economics and tourism, because it does seem the two might be very closely related, and it's difficult to see how one would deal with the tourist aspects, so on and so forth, recreational aspects, without having regard to the cultural heritage of the area. I cannot see how. Fine, thank you.
I think, to be fair, I think that's actually a typographical error for myself. It should be built heritage. So we're talking about archaeology, listed buildings, conservation areas. There will be some degree of overlap, and that's the nature of inquiries. But I think we can deal with that during a hearing session easily. Okay, moving on. In terms of access, traffic and transport, obviously NAT safeguarding have a holding objection. However, it looks like there may be a suspensive condition that could override that. I was proposing to ask for further written submissions to clarify that.
Yeah, well, it is. We are very close, sir, to an agreement on this matter. But if you want to, and again on the precautionary principle, request information, so be it. But I would anticipate updating on that in the relatively near future.
Any comment from any other party? No? Okay. In terms of other matters, so human health, ice throw, clue objection to 20 Shilling Wind Farm, I'm proposing that no further process is required. And that's agreed. Everybody's nodding around the table. Okay. And in terms of conditions and legal agreements, I'm proposing there that there's a hearing session and that hopefully we can have an agreed statement in terms of where areas of disagreement may arise in terms of the standard conditions. Is that agreeable to parties? Mr. Steele?
So the usual procedure is, as you outlined, that there would be a discussion session in relation to conditions. I don't think a Section 75 applies here, but that would be the usual process.
Any other comment?
I'm glad we have agreement to one hearing session, but yes, I would agree that a hearing session, and hopefully we can shorten it significantly.
Okay, if we look at item 5, that's participation in the inquiry sessions and other procedures. So obviously I expect the applicant to be involved in all the sessions, and I've given a provisional list of parties which I think would be best placed to share information on each topic. Now, in terms of those that I've listed, are we agreed that those are the parties that should participate?
Well, so I'd raised a query about SNH's participation in any policy matter, but I've simply asked to reserve my position on that, but we will inform you on that in due course. But subject to that, no concerns about the suggested participation.
Well, I've said I'm opting here for further written submissions, and I would copy Scottish Natural Heritage within that. I think based on Mr. Steele's submission, he has asked he's outlined a specific area that should be directed, and I feel that a further written submission would be the best way to deal with that, and SNH should be copied into that.
In those circumstances, I'm quite happy.
Right, well, if we work our way through, so we're all happy with who's involved in policy, just nod of heads, yes. In terms of landscape and visual impact, we've identified 5 parties, we're happy with that, yes. In terms of the socioeconomic session, everyone who is here would wish to participate in that, and obviously I'll give Scotways, the Lowther Hill Ski Club, David Mundell and Mary Steen the opportunity to participate in that session should they wish to do so. In terms of Pete, if required, that would just be the applicant and SNH. Yes. In terms of ecology, the applicant and Lead Hills Community Council. Yes, okay. And in terms of the NATS update, that would be the MOD and the applicant. Correct. Now, for condition session, I've said the applicant, the council, SNH, and the only other party that's raised an issue with conditions was the Wanlockhead Village Council. Would you wish to be involved in that session?
Yes.
Any other party wish to be involved? Mr. Finlay.
Can I just say, in terms of SNH's involvement in conditions, it may well be that that's all agreed, so there's no need for SNH to formally attend the session. And I'm sure Mr. Steele's information about the peak issue is correct, but we'll be looking, we can confirm that in due course, but I would hope that SNH's involvement insofar as conditions is concerned will be a matter of the conditions will be agreed or the council can deal with them.
We're going to come on to this further in the agenda, but you'll notice that I've put in brackets a list of statutory consultees that should be involved, and we'll come on to where I think the applicant could usefully help us in terms of coming up with a standard set of conditions. Particularly there we have South Lanarkshire Council who have asked for a legal agreement in terms of roads wear and tear, but we'll come on to that in a minute. So we're agreed item 5. Now, in terms of the hearing of evidence, item 6, now that we've agreed who's going to participate, it'd be useful to agree the order in which evidence will be taken in the inquiry sessions. Generally, we'd start with the applicant's witnesses and then move on to the council and others. Witnesses will read out precognitions, or if they're rather long, we can agree to be read and summarise them. We can then provide any clarifications for cross-examination and other parties, again the council and others, before questioning from myself and re-examination by the witness. Is that an agreed process?
Sir, that would be the usual process, and I see no reason to deviate from it unless you would find another process more helpful or another order.
Everyone's happy on this side? Yes, nodding of heads. Now, as I said, particularly for the two councils that are here, the Village Council, Community Council, you don't have to be legally represented, but you can act yourselves as someone that's asking the questions of one another, if that helps. Okay. For hearings, we'll all group around a set of tables, which will be a lot closer than we are today, and we'll discuss the topic following an agenda, which I'll issue in advance. Is that agreed? Yes. Okay, good. Okay, in terms of dates, location, and likely duration, I want to discuss the number of witnesses and potential duration of the hearing and inquiry sessions. Now, my intention is to hold the inquiry and hearing sessions in late August or September this year. Could I ask what availability do parties have over that period? Mr. Steele?
Yes, sir. I've already had a discussion with my learned friend. The date that we would propose is starting on the 30th of September, which was within the period that you suggested. Regrettably, we cannot, for complicated reasons, which I'll go into if needs be, but we cannot make a date earlier than that.
So, Mr. Finlay, your parties and witnesses are available for that week?
Yes, that was outside the period we were contemplating, but I've taken steps to ascertain their availability, and we are available that week and the next week, I understand, if necessary.
In terms of Mr. Mundell, would he be available then?
He'd be available Mondays and Fridays during the week, as long as he was given advance notice. He would have to be slipped from Parliament before he would attend.
Sorry, that was Mondays and
Fridays.
Okay, in terms of the Wanlockhead Village Council, your availability?
I will make sure my diary is clear.
Lead Hills Community Council?
Yes, we're happy we can attend then.
Right, and in terms of the number of witnesses, Mr. Steele?
Do you mean overall, sir, or do you mean for particular topics?
Well, sorry, I'll get your mic a second. Now, obviously, the complication here is that you've asked for inquiry sessions, and you will have heard that I've stated that I only want one inquiry session on landscape and visual impact. So what I'd like to understand is how many witnesses for landscape and visual impact and how many days you think you might need. And secondly, you probably want to indicate, if I was to opt to have an inquiry session for all the other matters, how many witnesses you would require. So I have the and or if.
Sir. Well, if I can just go through it in order in that case. The policy context session, we would have one witness, Mr. Bell. Landscape and visual impact, we will have two witnesses, Mr. Welsh and Mr. Van Brieken. The socio-economic, tourism, etc., we would have one witness for the economic issues, Mr. Graham Blackett, and if we proceed, or if the inquiry proceeds, or whatever it is proceeds, with flood risk and contamination, we may well have another specialist witness in relation to that issue. I'm afraid I don't know the name as to who that might be, but it might also be dealing with the hydrology and hydrogeology. Ecology, I wouldn't anticipate an additional witness for the mountain hare because Mr. Bell would cover that in his evidence as he would with ornithology and noise. If it's built heritage, if that's to be considered, sir, we have one witness that is available for that. Access, transport and traffic would be updated by Mr. Bell in his precognition, and the other matters listed below, if relevant, would be covered by Mr. Bell in a line or so. So there would be no additional witnesses if they're all to be treated as inquiries. And if I may respectfully say so, I do not think that there would be additional time taken, even if it was to be all dealt with by inquiry.
And sorry, particularly in terms of landscape and visual impact, two witnesses, how long do you think it would take you to examine them?
How long does it to examine them? Not long, sir, because my usual practice is to let the witness read the summary precognition. There may be one or two additional points that have developed, but not long. I prefer not to take a lot of time. The real issue is cross-examination by other parties and how long I might be cross-examining depending on how many witnesses are to be led from the other parties.
Okay. Mr. Finlay.
So, current intention, although we're still at early stages, to call one joint witness for the landscape and visual session, who would be Dr. Wimble, who you I think have come across before. For the hearing session on conditions, it would be Andrew Robinson. And I think those are the two main sessions.
Okay, thank you.
And probably Andrew Robinson for socio-economics as well.
Right. And in terms of the Wanlockhead Community Council and Lead Hills Community Council, I presume that you would have one witness?
Yes, I mean, we'll have a discussion amongst ourselves as to how we organise it, but there's certainly one witness, I would imagine. Yes.
And when you said that, that's interesting. So are you talking about working together as one rather than separately?
We worked together at the Harryburn inquiry. It did have certain advantages, but we may well work together here. That there are certain sort of slight differences of viewpoint, but we'll see if we can. We'll discuss those amongst ourselves and sort that out. Can we say at the moment then that we'll do it separately, but we'll resolve this in that it may be more efficient if we both cooperate.
Okay, so in terms of the note of today, I'll say that you're going to work separately, and therefore you'll be submitting separate inquiry and hearing statements and relying on one witness each. However, I will stipulate that you could combine, and therefore you would only require to produce one statement, one recognition, one witness.
Yes, I mean, it comes down to resources, basically. We're a small community, or both communities are very small.
So now, finger in the air time, how long do you think we would require for, in particular, the landscape and visual impact inquiry? Mr. Steele, any indication from what you've heard from the other side?
Not really, sir, because every prediction is always wrong at this stage. But it may be that it would be completed within 1 week. It may be that it's going to spill over. I would have thought the precautionary approach is to set the inquiry down for the inquiry session or sessions, as the case may be, down for 2 weeks.
Mr. Finlay, any comments?
Well, I agree with Mr. Steele that predictions are difficult to make accurately. In terms of the landscape and visual session, I've come across both Malone Friends witnesses before, so I have some indication. I would have thought 3 days at most for landscape and visual, and then difficult to determine what the other days would be. But we may, I can see that we may, if we have 4 days in the first week, may slip into the second week. But I would be surprised if we took it all.
For the avoidance of doubt, sir, I agree with that. I think we might well spill into the second week, and I'm simply suggesting we mark down the entire second week. We've also got site visits to think of, and closing submissions and so on and so forth.
I mean, simply looking at this, if we're talking 3 or 4 days for the landscape and visual impact evidence to be examined, cross-examined, and I probably would suggest a day for the socioeconomic hearing session. So that gives us a week, and then we're spilling on to a second week definitely for the hearing session on conditions and legal agreement, albeit that I would anticipate that would only take half a day in practice. So I think if we suggest from the 30th September, that full week will be landscape and visual impact assessment plus the socio-economic hearing session. My preference would be if we could keep the socio-economic hearing session to the end. Would that be agreeable to parties? We have an option. We can either make it the Monday, so it's the first session to include Mr. Mundell and possibly David Mundell, or the Friday, so we can incorporate those. Mr. Steele.
I wonder, sir, if you might think about making that session following Monday, which would allow Mr. Mundell to attend. It also would allow for anything going awry on week 1. It might also allow a day for site visits during the first week.
Okay, sorry, Mr. Finlay. Yes.
So were you intending to start the inquiry on Tuesday or the Monday of the first week? There might be some advantage starting it on the Tuesday, but
So as a matter for you, Mr. Innes suggesting we start on Monday. I personally thought you might start on Tuesday. We're pretty relaxed one way or the other, but whichever it is, one would hope to get through the landscape and visual on week 1, and other matters. If we did the socio-economics on the following Monday, that would seem to be useful for various points of view.
And do you think we could fit the condition session in? That would have to come after the socio-economics, just to make sure that anything that arises in that session could be picked up in the condition
I think
session.
that would be prudent, sir. Therefore, that might be later on the Monday. That might be Tuesday.
Right. My preference would be to start on the, well, this depends on how far people have to travel and whether or not a Monday is accommodatable. You're saying Tuesday, Mr. Steele, would be preferable?
Sir, I'm saying it's entirely up to you which you prefer. We'll be here, whatever you say.
Mr. Finlay, any comment in terms of Monday or Tuesday?
well, simply this, so that I think the landscape and visual session, I think Mr. Stepman back, I think it's sensible to programme the socio-economics and conditions for week 2. I don't think landscape and visual is going to take more than 4 days. I think it might be less than that. So that if one is going to take 4 days of week 1, then there's an advantage in starting on Tuesday rather than on the Monday. That's all I would say.
Right. Well, let's make the start date the 1st of October, I think. Is that the Tuesday? And then we can work out the rest of our dates after that. Yes, so Tuesday the 1st of October, and we'll pencil in the 4 days there till the Friday for landscape and visual impact. And then the following week, the Monday, the 7th of October, we will have the hearing session, socioeconomics and community impact. And the Tuesday, we will have the hearing session on conditions and legal agreements, if any are required. That would then leave the Wednesday, potentially the 9th, for an accompanied site inspection. Is that my preference would be for that, simply because the landscape witnesses tend to still be around, although based on our programming now you would have to come back. So would Wednesday the 9th work in terms of your landscape witnesses on both sides?
Well, sir, I'll check on the date just in a second, but we have a proposal in relation to the site visit, because we have carried one out with a view to saving your time very, very considerably, because we are able to arrange access, vehicular access to the site and to various other points, particularly Lowther Hill, which without an appropriate driver and an appropriate vehicle would be very difficult to achieve. And therefore, if you're going to walk the site and the southern upland way or parts of it, frankly, there'll be days involved in it, I would imagine. It's fairly extensive. On the other hand, we managed to drive it all, including many of the viewpoints, comfortably within a day. So that would mean it would have to be an accompanied visit to do that, because we couldn't drive you in isolation, and we would be asking for a representative from the council and the community as well. But that's simply for your convenience, sir, and to save you a considerable amount of time.
Okay, well, that's much appreciated. I think we'll come to that in a minute in terms of the actual what will be part of that. But in terms of the day to set aside to do that, are we happy with Wednesday the 9th of October?
The short answer, sir, is I believe yes. Obviously, we'll need to secure agreement from various parties to that. But if that is the proposal, sir, we'll need to arrange a suitable vehicle or vehicles to achieve that as well.
Thank you. Now, in terms of venue, Samira Akbar, the case officer, found it difficult to find a suitable venue in this area, particularly one that had good Wi-Fi. Should we use this hall, or is there another hall that would be more suitable to use? I'm probably looking at this side of the table because you have local knowledge, but...
As chair of the Wanlockhead Community Centre scale, it would be nice if you could put our hall forward. However, we cannot guarantee Wi-Fi coverage.
I have a hearing impediment, and I find the acoustics in here very good. So I'm happy with this venue, but obviously you've got to take other views into account.
Well, I mean, for ourselves, this is a fine venue. It's more in terms of Wanlockhead Community Council and Leadhills Community Council. You're having to travel each day to here, but you're happy to be here. Excellent, good. Well, we'll try and book this hall out. The only disadvantage, well, the advantages of this hall are, again, the acoustics. It's a good size. There are toilets. There's a kitchen facility, so with a microwave and kettles. There are lunch venues within the village itself, so that makes things a bit easier. Disadvantages, there isn't a Wi-Fi, but we can record and upload our recordings each night, so they will be available online. So we'll try and book this out. The only other disadvantage is probably we may, on some occasions, have to pack up everything in the hall because there are evening activities. There's also a nursery that happens next door for 1 hour twice a week, so it shouldn't interrupt too much, and the nursery children won't be able to come in the hall. On that basis, are parties happy to use this hall? Right, now, moving on to item 8, procedures for hearing inquiry sessions. Now, in all cases, prior disclosure of cases is very important, so parties taking part in the oral procedures will have to disclose the case they will lead in advance. Now, for further written submissions, I'll provide the timescale and a procedure notice to be released with a note of this meeting. Usually I give a period of 14 to 21 days to comment, and 14 days to respond is sufficient. Now, in this case, I think the further written submissions, I'd be asking for 21 days with 14 days to respond. And generally what I like to do is also add a further 7 days for the applicant to provide the final say. Is that agreeable in terms of further written submissions?
So far as those dates are concerned, that's absolutely fine.
Any comment from this side? Nodding of heads? Yes, good. Okay. Hearing statements. These will be required for those taking part in the hearing sessions. They may be collated into one document for ease. The statement should contain full details of the case that will be put forward, list the documents that will be related to, and specify those who will take part. The statement should be lodged 4 to 6 weeks in advance of the start date, along with any documents that are going to be referred to. I'd like to stagger the date of submissions for the hearing statements and inquiry statements, so suggest that hearing statements are submitted 4 weeks in advance of the start date. Is that agreeable?
So that the dates themselves are fine.
Mr. Finlay and everyone this side, happy? In relation to the hearing on conditions, the Energy Consents Unit, which is the section of the Scottish Government which deals with applications under the Electricity Act, and the Heads of Planning Scotland have a generic list of draft conditions which can be used as the basis for the specific conditions that may be issued for a particular wind farm if consent is granted. Now, I can circulate that to parties if required with a note of this meeting, although it is, you're nodding, Mr. Innes, it is available. Yes, good. I'd expect these conditions to be the starting point for a set of conditions to be agreed between the applicant, the council, and any other interested party, including statutory consultees, to be produced in advance of the hearing session on that topic. Is this agreeable to the applicant and the council? Yes, the council's nodding as well. Now, would any other parties wish to be involved in that agreed statement? Wanlockhead, Village Council, you're coming to the hearing session. Yep, okay. So we'll have to make sure that the applicant, that you copy in Wanlockhead Community Council into those exchanges, and also SNH. Now, the agreed statement should be submitted 4 weeks in advance of the start date, together with the hearing statement, as outlined earlier, covering the principal differences between the parties. Although I do note that ongoing discussions may necessitate a later submission, as version control, things can change over time. Now, are we agreed on that? And is it okay for the applicant to take the lead role in producing that document? Yes, okay. Now, again, I'd hope in terms of policy matters, the applicant and council and others could provide a statement of agreed policy documents and policies. Is that agreeable?
So is this in relation to item 1 on your list? This is
yes.
Back to the policy.
Yes.
We have already indicated we'd like to agree as much as possible in relation to relevant policies, not relevant policies, and their applicability, so on and so forth.
Okay, well, again, I'd look for an agreed statement to be submitted 4 weeks in advance of the start date. And again, it should set out the agreed relevant policy context and highlight any areas of dispute. Again, could the applicant be the lead on that? Yes. Okay. And the council and SNH, you're happy to be involved? Yes. Okay. Inquiry statements are required for those taking part in the inquiry sessions. The statement should provide the particulars of the case that will be put forward, list the documents that will be referred to, specify the witnesses that will give evidence, and who will be leading the case and cross-examining. The statement should be lodged 4 to 6 weeks in advance of the start date. Now, in this case, I think 6 weeks in advance would allow for parties to fully prepare their cases and allow a staggering of submissions. Is that agreed? Right.
So, just want a bit of clarification, if I can, what you mean by inquiry statements. Do you mean a short statement setting out the ambit of the case, or are you thinking the full evidence? Sorry.
So there, sometimes, in fact, probably more commonly now, we get a statement which is an overview, which can be useful, or it may not be useful depending on your point of view. Beyond that, when we ask for documents to be submitted, what regularly appears to happen now is that an inquiry report is submitted as a document, and that seems to contain more evidence. And then 2 weeks in advance, as you know, a precognition is submitted, which tends to be a summary of that document. That, I would suspect, would be the process in this case. But as I've discussed, the principle of prior disclosure, I would hope that anything in an inquiry statement, anything in a document that was submitted didn't suddenly come out of the woodwork with something brand new to surprise another party. Is it?
That in mind, and it may be worth having inquiry statements slightly longer in advance, saying 8 weeks in advance, so that parties can then react to what's in the inquiry statements before they produce their documents, their inquiry report, and then the precognition, as you suggest, 2 weeks beforehand. It's just so that parties are aware of the ambit of the evidence that is likely to be called.
Mr. Steele, are you agreeable to that?
Leave it to you, sir.
We'll agree on 8 weeks then for the statements. I mean, we have a good lead-in time to the 1st of October, so we can accommodate that. Sorry, Mr. Godfrey, did you have a comment? No. Right, those giving evidence at the inquiry sessions should also provide a precognition, and that's statements of evidence that will be read at the inquiry sessions of no more than 2,000 words long. That should be submitted 2 weeks in advance of the start date, which I think we've all agreed. I think, and I've had this in the past, a statement of agreed matters on landscape and visual impact would also, I suggest, be a suitable starting point in enabling parties to understand the key areas of dispute. Would you be agreeable to producing a document setting out areas of dispute on that, Mr. Steele?
Yes, sir. If you find that helpful, we can do that in cooperation with the other parties.
Indeed, it can be helpful, and one of the items it can agree is, whether the visualizations are deemed suitably accurate and the like, and so I think it is a helpful exercise.
Okay, in terms of, you've predetermined me in a sense, because I was going to suggest this could be produced 8 weeks in advance so that people saw it before the inquiry statement. 10 weeks might be stretching it in terms of our time scale here, so are we happy for that to come in at the same time as the inquiry statement, so 8 weeks in advance? And what I'm looking at here, when I was looking at the environmental statement, FEI, and where parties are at, the areas of dispute seem to be rather narrow. So I'd like you to focus on those areas of dispute. So anything that you're in agreement, if you're in agreement on the methodology, please just give me one line that says, we agree in the methodology, we agree the visualizations. So wherever you don't agree, that's what I'm interested in. And it means that for the Minister in particular, I can highlight these are the areas of dispute, and it means when we get to the inquiry itself, we know exactly what we're talking about. That's agreeable? Good. Now, as we discussed, documents, they should be submitted for the hearing and inquiry sessions, and they should be provided 4 weeks in advance of the start date. The applicant and the council and SNH should liaise in producing a list of core documents and decide who should produce what. You may also want to involve other parties, so Wanlockhead Village Council and Lead Hills Community Council, in that core document list. Is that agreeable? Yes, nodding, good. Please note that the DPA has a core document library which contains many key documents, including National Planning Framework, Scottish Planning Policy, and the current Dumfries and Galloway Local Development Plan. A copy of the development plan and relevant supplementary guidance will be required no matter what. I will require an electronic copy of any documents, and I suggest that all parties are amenable to working electronically where possible. Is that agreed? Yes, nodding of heads, good. Now, all relevant papers associated with the case, including all the environmental information, will be placed on deposit by the Council for inspection by members of the public. Now, where should the papers be made available for inspection?
Apologies as yet, we've not made investigations as to that, but I wonder, would there be facilities within this hall? Is the hall kept open Monday to Friday, 9 to 5?
I couldn't say. The council normally deposits documents with the local library here, but it's the hours are fairly restricted.
And they haven't got the space.
Right.
Can I just say that when the actual application was first made and the documents came into Sanquhar, they were kept in the local library. They were in a cupboard. No one knew about them. And after several weeks, when Wanlockhead found out about them, they were produced and put out locally. They were out for 3 days, and they were told to put them away. So there needs to be somewhere where all Sanquhar residents, and I'm talking about Sanquhar residents here, because Wanlockhead will make available their hall for their copies so that everyone in Sanquhar and Lead Hills can come and examine them. But somewhere in Sanquhar particularly needs to be open and available, and that residents, all residents, must be notified that these are here for viewing. Not particularly just through the Sanquhar Community Council, which I notice are not represented here today.
Thank you. Obviously, Sanquhar, the Royal Borough of Sanquhar, I think their community council, they've actually written support, so they're not here today. I hear what you're saying there about in Wanlockhead, you'll have them available 24/7. So perhaps that's where we should deposit the documents if you're going to make it available. Would that be amenable? Would that be okay? Okay. Could I get the address of that just for the note? Thank you. Well, it'll be a liaison between yourself and the council officers. Thank you. Okay, now papers includes the further written submissions, the hearing statements, inquiry statements, all documents and the precognitions. The council should bring this public set to the oral sessions as well. Copies of the document statements and submissions have to be exchanged between the parties taking part in the various sessions. I will leave it to parties to agree between themselves whether to send these to each other in hard copy or electronic form. The parties must send the council one copy of these in hard copy for putting on public deposit. Where possible, I would like electronic submissions made in a Word format. It means that we can copy and paste and search easily, and we will PDF them once they come to us. I already have hard copies of the environmental statement, including the landscape and visual impact assessment and further environmental information. So that I don't need to transport large, heavy quantities of paper, I will view documents on my laptop during proceedings. I have no issue with others doing the same on tablets or laptops. But please note that there aren't many, I think, power sources in this room. I don't know if there's one behind yourself and on that side. So obviously there's going to be a lot of extension cables. So can you bring your own duct tape to secure those down? That would be much appreciated. We'll publish all the documentation produced on the DPA website. It is also possible, like today, that all oral sessions will be filmed. If you have any concerns regarding filming, then please come to me and have a chat. Now, in terms of item 9, other matters, the daily programme during the inquiry sessions will be to start at 10 a.m, possibly 9:30 depending on progress, and we'll work on until 4:30 or 5 with an hour break for lunch. Short comfort breaks will also occur mid-morning and mid-afternoon. In terms of site inspections, I will carry out an unaccompanied series of site inspections in advance of the inquiry. In fact, I was on there last night on the edge of the application site. And that will start to provide me with a feel for the area and the viewpoints. Now, I'd also like to carry out an accompanied series of site inspections with the aid of parties, which Mr. Steele's also alluded to. Now, would an accompanied site visit be useful before the inquiry, or would it be better after the inquiry?
So I was just going to suggest that to you. Personally, I found the site visit that I did in the last few days utterly invaluable, and I would have thought that it would be helpful in understanding the evidence that is to come thereafter. So either before the inquiry starts at all, or perhaps even during the first week when you've heard some evidence and are about to hear some more, that might also be another opportunity to do that. But perhaps that would be the time to do the site visit, which we would drive you round the site and other locations.
Okay, well, we're starting on the Tuesday. Perhaps Monday the 30th of September is an opportunity, when I'll be here anyway, to conduct that accompanied site visit, and it will be fresh in the mind of the landscape witnesses. Can we go ahead on that? I mean, we said the 9th previously, but I'm happy with Monday the 30th.
Yes,
I suggest, sorry to cut across my own friend, is that the day before may be the time when advocates are wishing to speak to their witnesses in preparation for cross-examination. So I'd actually prefer if the site visit wasn't on the Monday beforehand for my purposes and those of Dr. Wimble.
Right. Is there a date in September that we could usefully use then? Or are you happy for me just to select a date and go ahead on that basis?
Sir, firstly, the day before the Monday would suit us perfectly well. We will have had our consultations by then. So if that suited you, we're perfectly happy with that. Alternatively, if a day the previous week suits you, we're happy to try to accommodate that as well. Mr. Innes is suggesting we set aside 2 different days because of the weather.
In that case, why don't we say the 24th, 25th of September? It's a Tuesday, Wednesday. Okay.
And for that, we would intend to provide one vehicle, unless you wish two, and one representative from each party, together with yourself, could be accommodated in the vehicle, unless you want two vehicles.
This all depends on how many people are attending. So there's myself. How many landscape witnesses? You have two landscape witnesses?
We have two, sir, but we would be content if one went. If we are tight for space, obviously we'd prefer two.
And Mr. Finlay, you'd want Dr. Wimble to attend?
Yes.
Lead Hills Community Council 1 and Wanlockhead Village Council 1. That would be acceptable.
Could I make a point? If you're going to the Lowther Hills Ski Club, the road to the radar station, which is the access road, is a gated road, and you'd need to make arrangements for that gate to be unlocked.
Well, so that's precisely why I'm offering to do it, because we have access to the key for that, and we can facilitate
fine.
that.
If you have difficulties, we have a key as well.
Of keys. So in terms of my list then, so accompanied, what is it from the unaccompanied section there that you would like to be pulled into the accompanied?
Well, sir, firstly, it seems to me it's two vehicles from the numbers that have just been outlined. Secondly, if you want the detail of this just now, sir, we would prefer just 10 minutes to go through this, but broadly speaking, it would be the site, Lowther Hill, could readily be accommodated together with a number of the viewpoints. It may be preferable and a better use of time to agree this between us subsequently, a list to go round that can be readily accommodated in one day. But if you want it now, sir, I'd need 10 minutes to.
What I'll do after this, I'll simply ask probably 14 days or something just to give me a list, and we can agree that. It just means that I'm not going up Lowther Hill and then you tell me we're going up together, or for any of the other sites. Now, in terms of the list of accompanied, unaccompanied, is there anything missing from that list that I should really be attending and viewing?
Well, sir, we don't think there's anything significant that's missing from that.
And in terms of the no visit required, you'll see I've noted Black Craig Hill and Tinto Hill. Are parties happy that I don't ascend those summits? And in terms of the unaccompanied visits, are there any, we've heard about the key to Lowther Hill, but that's, we've got past that. But are there any other barriers to me accessing the application site or any of the viewpoints? No? Okay, great. Okay, that's agreed. Now, I'll do a note of this meeting and an accompanying procedure notice, which will contain all the relevant dates that we've agreed today and the contact details, which will explain who is to submit what and when. There'll also be an inquiry timetable at the back, so you know exactly what you need to do when. The case officer, Samira Akbar, is always available should you have any questions about the process or proceedings. So you can contact her. And I will provide her with details within the note of this meeting. Are there any other relevant matters that anyone would like to raise?
If you just give me a moment, please. Yes, sir. Can I just return to the thorny matter of the inquiry, in particular in relation to the policy session? Firstly, sir, I repeat again, there is a legal requirement to have an inquiry session. There is a particular purpose and requirement by us to have an inquiry session for the policy context, and it is my submission that our case will be significantly prejudiced if we do not have an inquiry session in relation to the policy matters, and a witness from SNH, because we do wish to test what their policy may or may not be, and we set this out in our position statement of November 18. And I would, with the very greatest respect, ask you to reconsider that matter and to note in detail, and I hope it's being, and I know that it's being recorded, that submission, sir. because we will be significantly prejudiced, I repeat, without an inquiry session for policy matters. And in addition, as the first point, of course, there is a requirement to have a policy session dealt with by virtue of the terms, the clear, unambiguous terms of the Electricity Act 1989, Schedule 8, to which I've already referred, sir. And I hope that you've noted that and will, with respect, reflect on it.
Mr. Finlay, any comment?
No additional comment to that which we've made already.
So just to clarify, in terms of an inquiry session on policy, it seems to me that the scope of a policy inquiry session is rather narrow in the sense that you're just trying to look at SNH's policy with respect to the geographical spread in this particular area. Is that correct?
That is but a part of it, sir, and their policy in relation to energy matters. And we also wish to lead evidence and cross-examine about government energy policies and the emerging climate change positions of government.
Okay, so I understand the SNH point of view. Who is it that you want to cross-examine in terms of national energy policy?
We wish to lead evidence about that, sir, and we also wish to cross-examine the relevant witnesses from the opposition as to their approach and what weight they attach to those matters. That would be both the Council and SNH.
Sure, SNH take a position on national policy, energy policy matters and the like, but certainly it does seem to us that this can all be perfectly adequately dealt with by written material. There's no real dispute as to national planning or energy policy, or indeed local planning policy. It's a matter of emphasis and weight, and that can be conveyed in any written evidence.
Okay. Sorry, Mr. Steele.
Well, sir, simply to say, sir, that there are disputes about that very matter, and that is why we wish Mr. Bell to lead evidence about it and to cross-examine about it. There are absolutely significant disputes in relation to national policy and the weight attached to it.
Okay, and when we're talking about this, you're talking about Dumfries and Galloway Authority.
Yes, and SNH as well. Yes is the answer to that.
Okay, you've already heard my ruling, essentially, is that I would like to stick with the Code of Conduct. I think a further written submission process is adequate for this particular session. However, that is not to say that during the conclusion of that, I may not think it appropriate that we require a further session and possibly an inquiry session on policy matters. If that were to arise, I would suggest that possibly Monday the 30th of September in the afternoon, because I wouldn't expect this to take a long time, could be accommodated for that if required. But that's something that I will take on board and have to come to determination on in terms of writing up the procedure notice today. So from the outset, there will be a further written exchange, and I will review it beyond that and determine whether or not an inquiry is or isn't required. Are parties happy on that basis to continue?
Well, clearly, sir, my submission is that there should be an inquiry now, so obviously I cannot agree that I'm happy with that at the moment, no.
Mr. Finlay?
Yes, sir. Continue on the basis that you've outlined.
Right. Are there any other relevant matters? No, in that case, thank you very much for your attendance today. If you have any questions, you can ask me at the end of the process today. Safe home, and I will see you in October. Thank you.